Trudeau was very anxious to relaunch the constitutional discussions, and he sent Mr. Chrétien around the country. I remember, I think it was just about the day after the referendum in 1980 that Jean Chrétien met with myself and Premier Davis, and that started what turned out to be a long, hard summer of negotiations where all groups, ministers from every province were traveling different parts of Canada trying to put together a package that involved 12 different subjects. And Jean Chrétien, and of course, as the Minister of Justice, and Roy Romano as Attorney General for Saskatchewan, were the co-chairs of the summer's negotiations, which involved a number of public servants from each province and the federal government. And because of their own cultural backgrounds, I think they were nicknamed the Took and Uke Show. But Romano had been a very close friend of mine since I had become the Attorney General in '75, and I'd come to know Jean Chrétien, and as a result of that summer in particular, we became pretty close friends, as did a number of the ministers representing the various governments, which was important because when push came to shove, you had a lot of fairly close relationships, the closer between the ministers than the premiers, because we saw a lot more of each other than the premiers saw themselves. Now, unfortunately, the First Ministers' Conference that was supposed to be resolve this thing in September 1980 broke up into well, it became very fractious, and I realized that we weren't going anywhere. Unfortunately, federal-provincial relationships at that time were very strained, and Mr. Trudeau was very unpopular with a number of the ministers, and so it was very difficult to reach a consensus, and actually the whole meeting was a bit of a failure, except for the fact that I think the summer that was spent between with the senior ministers from across the country created a network, which I think proved to be very important towards the end. But Mr. Trudeau, Prime Minister, then announced that he was going to proceed unilaterally to the United Kingdom and simply ask the British government to pass the legislation without the support of any of the provinces. Certainly Bill Davis of Ontario and Richard Hatfield of New Brunswick understood the frustration and the fact that we had to do something dramatic, because governments had been debating this for more than 50 years, and there was no amending formula in the original Constitution of 1867, because it was just assumed that any amendments would only be carried forward by the British government, because in 1867 the reality was that Canada was really a colony, a glorified colony, albeit with a substantial domestic independence, but when it came to our foreign affairs and the amendment of the Constitution, we were still in a bit of a colonial status. And this became very embarrassing as the years and the decades added up, because Britain would have been very happy to see the patriation of the Constitution 50 years earlier than it happened. But they couldn't get any sort of an agreement between the federal and the provincial government. Constitutional advisors advised the Prime Minister that they could proceed unilaterally. But of course the provinces were furious with this, and they launched 3 court challenges in the provinces of Quebec, Manitoba, and Newfoundland. And I spent some time in the UK, in London in particular, in early 1981, meeting with Sir Michael Havers, the Attorney General, Briton who had become a friend of mine, and he made it very clear that the British government would be very reluctant to pass the legislation, regardless of the legal arguments, with these court challenges in Canada. And his personal advice to me was get this case to the Supreme Court of Canada, which did happen in, I guess, in April of, towards the end of April in 1981, because he said the British government didn't want to be embarrassed with a possible patriation package and then having the Supreme Court of Canada down the road finding that it was unconstitutional. And a very good legal argument could be made out that the federal government had the right to unilaterally request the patriation package from the UK, but the Supreme Court of Canada undermined that argument, and as I think for good reason, although Mr. Trudeau never thought so, when they said that yes, from a strict legal, from a strict constitutional standpoint, that Canada could make the request unilaterally. But at the same time, and this was the key point, there was a constitutional convention that existed that indicated that some support of the provinces was required. Now, the academics sort of were of the view that if you required support of the provinces, that it would require the support of all the provinces. Otherwise, it would appear to be first and second class provinces. But the Supreme Court of Canada came up with a very unique, original view of the matter and said that it did not require the support of all the provinces, but just substantial support, as you know, without indicating exactly what that meant so far as the number of provinces. Well, I know Mr. Trudeau that he was absolutely furious, but he and Bor-Alaskan, who was the Chief Justice of Canada, he was very dismissive of the majority's decision on the convention case and said that it was a non-justiciable issue and that the court shouldn't even answer the question, because basically the view was that it was really a political science question and not a legal question, and if there's a breach of the convention, the consequences are political, not legal. But as it turned out, the decision, which I think was largely authored by Brian Dixon, forced the Prime Minister, who was realistic, to know that he needed the support of some provinces to get this passed in England. Remember, he was furious. I remember him telling me personally that he even talking about leaving the Commonwealth if the British government weren't more cooperative. But in any event, we did have the fateful meeting in November of 1981. Now, Sean Chrétien and Roy Romano and I and other ministers, I mean, we'd been meeting over many months, and the so-called Kitchen Accord was just sort of a summary of what we believed. It was just sort of well, I mean, just to say, okay, I think we're on the right page. We've been talking about this for months, and I think this is what will perhaps get a breakthrough. And we wrote out very briefly an accord that is now in the Canadian archives, and which talked about an amending formula and the not important notwithstanding clause, and there were a couple of items with respect to the marketing of natural resources. Now, I knew most of the other premiers well, and I knew that there had to be a graceful exit. I mean, as we all know, when you're battling with an opponent over something, that a useful strategy is to give your opponent a graceful exit if you can do it. And in this case, I believe that the notwithstanding clause would provide the key a gang of 8 opponents who were led by Peter Lougheed and Alan Blakeney, who believed very strongly in parliamentary supremacy, well, as did Sterling Lyon of Manitoba, but he had to go back for an election campaign halfway through the meeting. And the notwithstanding clause, I believe, would never really be used outside of Quebec, and I felt that this was the graceful compromise, which I am glad that our distinguished constitutional historian Peter Hogg has agreed that it was a credible credible compromise, a principled compromise, and because otherwise we wouldn't have obtained the agreement of everybody but Quebec in November of 1981. Now, at the same time, I have to say that Mr. Trudeau was furious because he had, I mean, to him, this notwithstanding clause sort of watered down the principles of the Charter of Rights. I didn't believe that it did, and time has proven me to be correct, because outside of Quebec it hasn't been utilized, I think once on a minor matter in Saskatchewan. And if it hadn't been for that decision on the with respect to the requirement of some substantial support of the provinces, I personally believe that the Constitution would still be back as an act of Britain. But Mr. Trudeau, notwithstanding his pleasure that the whole issue had been resolved, he still never forgave the Supreme Court of Canada, the majority on the